All right, let's get right into it. Today, we're taking a deep dive into a concept that's at the absolute heart of criminal law, mens rea. You've probably heard the term, it's Latin for guilty mind, and it's that crucial mental element, what's going on inside someone's head, that can turn a simple act into a serious crime.
I mean, really think about that for a second. If two different actions end up with the exact same tragic result, should we treat the people who did them in the exact same way? The law's answer is a firm no. And this question right here is exactly what the whole idea of mens rea tries to solve. It's not just about what you did, it's about what you were thinking when you did it.
So, here's our game plan for this explainer. First, we'll nail down what mens rea actually is. Then, we'll tackle the huge difference between subjective and objective fault. After that, we'll explore the three big levels of blame: intention, recklessness, and negligence. And finally, we'll wrap it all up with a nice, clean comparison.
Okay, let's start with the basics. Pretty much every crime is made up of two parts. You've got the actus reus, which is the guilty act, the physical thing you did, and then you have the mens rea, the guilty mind. And here's the key. For most crimes, you need both. You need the act and the guilty state of mind at the same time to be found guilty.
This quote from the philosopher H.L.A. Hart really gets to the why of it all. Why do we care so much about the defendant's mindset? Well, our whole system of justice is built on the idea of personal choice and responsibility. We punish people who had the ability, the capacity, and a fair chance to follow the law, but made a conscious choice to break it. Now, if you're going to understand mens rea, you have to get your head around this next distinction. It's probably the most important one in this whole topic: the difference between subjective and objective fault. It all comes down to the yardstick we're using to measure someone's mindset. And here it is, side by side. Subjective fault means we're trying to get inside the defendant's head. What did they actually know? What did they actually intend or foresee? Objective fault, on the other hand, is an external standard. We're not asking what was in the defendant's mind, we're asking what would a normal, reasonable person have thought or done in that exact situation. This table is a fantastic roadmap for where we're going next. You can see this clear hierarchy, this ladder of blame. Right at the top, you have the most blameworthy states of mind, the subjective ones, intention and recklessness. And down at the bottom, you have the objective standard of negligence. This hierarchy is so important because it doesn't just determine guilt, it often has a huge impact on sentencing. So let's climb to the very top of that ladder and talk about the most serious level of mens rea, intention. This is seen as the highest level of fault because it's a direct, conscious choice to make something illegal happen. But you're about to see that what the law calls intention is a little more complicated than how we use the word every day. See, intention actually gets split into two categories. You have direct intent, which is super simple. It was your goal, your purpose, your main aim. You wanted that result, period. But then there's this other, trickier concept called oblique intent. This is where you might not want the result, but you know it's a virtually certain consequence of what you're doing. The classic example is someone who puts a bomb on a plane to collect insurance money. Their direct intent is fraud, but they have an oblique intent to kill the pilot and passengers because they know their deaths are a virtual certainty of the bomb going off. Now, the courts really wrestled with this idea for years. You can see the whole story right here. Back in 1975, in a case called Cunningham, they said foreseeing a likely outcome was enough for murder. But then they started to backtrack. In Maloney, they said, no, likely is too low a bar. Then in Nedrick, they brought in this much stricter, virtually certain test. And finally, that was cemented as the law in the huge case of R. v. Woollin. The test got narrower and narrower over time. And here it is. This is the key direction that a judge has to give a jury, straight from R. v. Woollin. It sets up a clear two-part test. The jury can only find intention if 1, they're sure the terrible result was a virtual certainty of the defendant's actions, and 2, they're sure the defendant knew it was a virtual certainty. You have to prove both. That's the law today. Okay, let's step down one rung on the ladder of blame, from intention to recklessness. With recklessness, we're no longer talking about wanting a result or seeing it as certain. No, recklessness is all about one thing: seeing an unjustified risk and deciding to take it anyway. The definitive test for this comes from the case of R. v. Cunningham, and the key word here, the one to underline, is aware. To be reckless under this test, the defendant has to have actually been aware of a risk. Their mind has to have thought,
hey, this might cause some harm, and then they went ahead and did it anyway. It's a subjective test. We have to get inside their head.
But what if someone tries to be clever and just ignores an obvious risk? Well, the case of R.V. Parker deals with that. You can't just get angry, slam a phone down so hard it breaks, and then say, oh, I wasn't thinking about the risk of damage. The law says that deliberately closing your mind to a risk that is screamingly obvious is the same as being aware of it. You can't use willful blindness as an excuse.
Now, for about 20 years, the law got really confusing. There was this case called R.V. Caldwell that, for certain crimes, introduced an objective test for recklessness. It said you were reckless if you didn't just see a risk and take it, but also if you failed to see a risk that an ordinary, reasonable person would have seen.
Well, thankfully, this objective test was seen as pretty unfair. I mean, it ended up punishing people, like the two young boys in the case of RVG and R, who genuinely just didn't have the life experience to see a risk that an adult would have spotted in a second. So the House of Lords got rid of Caldwell and brought the law on recklessness back to the pure subjective Cunningham test. What matters is what the defendant personally saw. All right, we've now arrived at the bottom of our hierarchy, negligence. And here's the big shift. Unlike intention and recklessness, negligence is a purely objective standard. We're not trying to get inside the defendant's head anymore. We're looking at their actions from the outside.
This slide right here is absolutely critical for any law student. It makes the difference crystal clear. It all comes down to awareness. The reckless person sees the danger, they are aware of the risk, and they go ahead anyway. The negligent person, on the other hand, is unaware. They don't spot the danger, but, and this is the key, a reasonable person in their exact same position would have. And here's the more formal definition. It's just a failure to live up to the standard of care that society expects from a reasonable person. It's about falling below a certain bar for conduct. Simple as that. And this case, McCrone v. Riding, is a perfect practical example. You had a learner driver who made a mistake and argued, hey, judge me by the standard of a learner. The court said, nope, absolutely not. When you're on the road, the standard is that of a reasonably competent and experienced driver. It doesn't matter if you're a learner. That's what an objective standard means. Okay, we have covered a ton of ground. We've looked at intention, recklessness, and negligence. So let's pull all those threads together and lock in what we've learned. This table is really your ultimate takeaway. It just lays it all out. You can clearly see that ladder of fault. We start at the top, inside the defendant's head, with the subjective standards of intention and recklessness. Then we move down to the bottom, to the external, objective standard of the reasonable person for negligence. The higher up you are on this table, the more blameworthy the law considers you to be. And this brings us right back to where we started. A person who is killed because of someone's negligence is just as gone as a person who is murdered intentionally. The harm is identical. So why does the law go to all this trouble to make these fine, sometimes difficult distinctions about someone's mental state? Well, it's because criminal law isn't just about punishing bad outcomes. It's about judging and punishing blameworthy choices. And that, in the end, is what mens rea is all about.